Assalamu alaikum warahmatullahi wabarakatuh. So today our session is the topic for our session is precautions we all should take while buying property. This is a continuation of the legal sessions we've been having every month with advocate of the High Court, Mr. Akmal Razvi, and so the session will be recorded and will be uploaded on our YouTube channel. I will put the link for the YouTube channel in the chat box. You can also view the previous sessions on our YouTube channel. And let's start. Mr. Akmal, please start.
Assalamu alaikum wa rahmatullahi wa barakatuh. Recent in the last few months, a lot of people have lost a hell lot of money by making bad investments. Real estate is supposed to be the safest investment in the world. And yet, people in Bangalore and in Karnataka and probably in many parts of India have lost crores and crores of rupees because they make bad choices. They don't take the precautions which are necessary before you buy a property. If you are part of the group of MJ Legal Sessions on WhatsApp, you would have seen that I have already sent the presentation. If you are not part of the group, please join that group. The link to that would be displayed in the chat box probably. So let's start the presentation today. It's a serious issue because one of the things that a person wants is a roof over his head. It serves two purposes. One is a roof over the head, and the other is that's an investment, which is not a very liquid investment. Liquid investment is investment where you can convert it into money as fast as possible. But it's a reasonably liquid investment. You have a buyer. India has a shortage of housing, and it's everybody's dream to have a house. Unfortunately, if you don't take the precautions, you're likely to lose your money, and that's very hurting because most of the cases in India, it's the life savings of people which go into an investment into a house or real estate. And if something goes wrong, that person basically loses his life savings and he needs to start his life afresh. So let me start the presentation and then I am okay with both ways. You can either wait for me to finish the presentation or you can start putting the questions in the middle also. I'll be happy to answer that. But maybe it's better that you hear the entire session first so that many doubts may be clarified during the presentation itself. You can make a note of your questions and you can even put it into the chat box. If your questions are not answered, then I'll try and answer it. So let's start what happened recently in Bangalore, especially. Precautions before buying a property. Recent frauds in real estate. Latest one is the Hermain developers. You had the IMA, you had Injaz, and you had ALA. The combined loss to the victims runs into several hundred crores. IMA, Injaz, and ALA were basically Ponzi schemes in which money was collected promising big returns, which returns were not paid from profits, but from the money paid by other investors. And as is the case with all Ponzi schemes, it continues until the people keep paying more money, expecting unreasonably high returns. And when that money dries up, the Ponzi scheme collapses, and people who have invested their hard-earned money lose everything. They don't know what to do about it. It's a complete loss to them. Now, basic rule is that anybody who promises you returns over and above 12 to 15%, or probably 10 to 12%, you need to be extremely cautious, because the business has become very competitive across the globe. And any investment above 10% is to be very carefully gone through, and you need to take your precautions to ensure that you don't commit a mistake. Now, what were the mistakes which were done by the victims? There are thousands and thousands of victims who have lost crores and crores of rupees. Now, this first thing was they didn't do their due diligence. The law in India is in Karnataka and in most of the states is absolutely clear that any person or entity which takes money from the public as deposits, promising returns, they have various laws which are called the protection of interest of depositor. Now, this act gives the power to the government to attach all the properties merely on suspicion that that property was either purchased or an advance was paid in respect of that property with the depositor's money. And that is why you will see that all the properties of IMA, Injas, ALA, they're all attached. And people who have entered into genuine agreements of sale or even who have sale deeds are stuck. It is making it difficult for them even to get back the money. They face a huge challenge in trying to get back their money, because they have to show that it was a genuine transaction, the money was honestly paid, and it is not the depositor's money which they paid, but it is their own hard-earned money, and they had made an investment only in the real estate. So the first rule that you should buy is, please never ever buy a real estate from entities which take money from people promising returns and who might be governed by the Protection of Depositors Act. The other question would be that, look, Harman never invited people promising returns. They were doing a straightforward sale deeds agreements. And why is it that those people are also in trouble? Now, what happened with Harman was basically 2-3 things. One is they entered into an agreement of sale for the same property with 2 or 3 people. Now, the question is, what could people have done? So please understand that it is much better and advisable to enter into a registered agreement of sale. The other precaution that you need to take is you need to take a paper notice inviting objections from the public regarding the property on which you are entering into an agreement to. And you need to minimize the gap between the agreement of sale and the sale deed. But let's be practical. Trust plays a very important part from the time you enter into an agreement of sale to the execution of the sale deed. The second thing that happened was that the sale deeds were done. People honestly paid money, but the bank loans were not cleared. And the person who purchased it now will be forced to clear the bank loan, which the owners of individual flats had taken, but had not disclosed it to the party when they were selling. And therefore, now it is upon them to clear those loans, because the properties now will be attached by the banks. One of the victims I know of has purchased a flat for more than ₹3 crores. He has a proper sale deed, but suddenly the bank has come saying that the owner has taken a loan on the security of the flat which was sold to this victim. But the question is, what could have been done? The normal rule is that if a loan is taken on security of a property, it is done by creation of something called a mortgage. Now, the mortgage is supposed to be registered. Therefore, the encumbrance certificate should reflect it. Now, the first thing they could have done is they could have checked the EC. What is an EC? A short explanation for that. Any transaction in respect of any property which is recorded in the sub-registrar office would reflect in the encumbrance certificate. Lawyers and purchasers rely on the encumbrance certificate to find out the chain of ownership changes that have happened in respect of that property. And therefore, the first thing they should have done is that they should have obtained an EC to find out whether a mortgage in respect of the loan was reflected in it or it was not reflected. Now, more importantly, many people don't know, and please understand this very clearly, that the loan can be taken by deposit of original documents and that mortgage need not be registered. So merely taking EC is not enough. A bank can give a loan by simply taking the original documents of the property, and they can give crores of rupees on the basis of something called an equitable mortgage by deposit of title deeds. Now, therefore, verification and obtaining the original sale deed by which the seller became the owner should have been taken at the time of the sale deed. Now, obviously, this victim, I can confirm it, did not take the original sale deed by which the seller had become the absolute owner. In fact, he fooled him in by saying that I'll give you that sale deed in a few days. I think I have misplaced it. So this is what was done, and he actually had a loan. He had given this property as a security for taking that loan. And this is where the victim has landed up. Now he is saddled with the entire cost of repaying the bank loan, because please understand that when a bank gives a loan, it's something called a secured loan. Means that that loan has to be repaid. If that loan is not repaid, irrespective of who has bought it subsequently, the bank has the power to sell the property and recover the money. तो थोड़ा सा उर्दू का भी जो लोगों को नहीं मालूम है, कोशिश करूंगा कि उर्दू में भी अपनी बात को रखूं. आप सब जानते हैं कि हरमैन डेवलपर्स, IMA, इंजाज, आला, इन लोगों की वजह से करोड़ों रुपए का नुकसान लोगों को हुआ है. IMA, इंजाज और आला बेसिकली ये धोखे की स्कीम थी. इसको पॉन्जी स्कीम कहा जाता है. पॉन्जी स्कीम के अंदर लोग पैसा लेते हैं आपसे कहते हैं कि आपको बहुत मुनाफा मिलेगा, हलाल है मुनाफा, इंटरेस्ट नहीं है, और इस तरह आपसे पैसा लेते हैं. ये कोई हकीकी बिजनेस के प्रॉफिट से आपका पैसा वापस नहीं करते हैं, प्रॉफिट समेत, फायदा समेत, लेकिन ये वो पैसा लेते हैं और फिर दूसरे लोगों को, जो इनके पास इनके पहले 10-12 लोगों को जो इन्होंने रिटर्न दिए हैं 20%, 25%, तो वही लोग पैसे वापस देते हैं कि भाई आप फिर हमको ज़्यादा दे दीजिए रिटर्न, और फिर दूसरे लोग जो हैं खुश होकर अपना सारा पैसा लाके लगाते हैं. आखिर में जब इनके पास कुछ बचता नहीं है, नया पैसा लोग बेवकूफ़ों की तरह लाके लगाते नहीं हैं, तो ये स्कीम कोलैप्स हो जाती है. तो ये स्कीम्स का जहाँ तक रियल एस्टेट का ताल्लुक है, इस स्कीम के अंदर जो धोखा हुआ उससे बचने का तरीका ये हो सकता था कि लोगों ने जो पैसे लगाए, कुछ लोगों ने उनके पास से प्रॉपर्टीज खरीदी, फ्लैट्स खरीदे या फ्लैट्स को किराए पे लिया है. अगर वो थोड़ा सा भी अपनी कानून को जानते होते तो उनको ये मालूम होता कि पूरे हिंदुस्तान के तकरीबन हर रियासत में एक कानून है जिसको प्रोटेक्शन ऑफ डिपॉजिटर्स एक्ट कहा जाता है. बेसिकली ये कानून ये बोलता है कि अगर कोई बंदा लोगों से ये बोल के पैसा लेता है कि मैं आपको मुनाफा करके दूंगा, तो उसको वो लोग डिपॉजिटर मानता है कानून. और ये जो कानून है, इसके तहत कोई सी भी प्रॉपर्टी जो किसी डिपॉजिटर के पैसों से खरीदी गई है उसको गवर्नमेंट अटैच कर लेती है. और इसीलिए आप देखते हैं कि सारी जो प्रॉपर्टीज हैं IMA की, इंजाज की, आला की, ये सब अटैच हुई हैं. और जिन लोगों ने हकीकतन भी इनके साथ डील किए हैं, एग्रीमेंट ऑफ सेल किया है या सेल डीड भी किए हैं, उन सबको बड़ा मसला हो रहा है. प्रॉपर्टीज अटैच्ड हैं, कुछ कर नहीं पा रहे हैं. बहुत वक्त लगेगा, इनको साबित करना पड़ेगा कि इनका डिपॉजिट से कोई लेना देना नहीं है. इन्होंने उस रियल एस्टेट प्रॉपर्टी को खरीदने के लिए अपना ज़ाती पैसा, ईमानदारी का पैसा देकर किया था, तो लिहाजा उनको वो प्रॉपर्टी खरीदने की और उसकी ओनरशिप की इजाज़त दी जाए. तो कोर्ट जो फैसला करेगा वो होगा, उसके हिसाब से जो भी होगा. अगर इनकी किस्मत अच्छी रही, प्रूफ अच्छा दे सके, तो इनके फेवर में हो सकता है. तो पहला रूल ये है कि आप खुदा के लिए, अल्लाह के लिए कोई ऐसी प्रॉपर्टी ना खरीदें जिसको बेचने वाला लोगों से डिपॉजिट लेके उनको फ़ायदे के साथ वापस करने का वादा करता है और बहुत सारे लोगों से लेता है. इसलिए कि वो सारी प्रॉपर्टीज अगर खुदा ना खास्ता उनकी स्कीम फेल हो गई اور جو ہونا لازمی ہے اس لیے کہ آپ سب کو یہ معلوم ہونا چاہیے کہ جو بھی شخص آپ کو 10 سے 12% سے زیادہ ریٹرنز کا وعدہ کرتا ہے سالانہ، اس کے ساتھ آپ کو بہت کیئرفل ہونا چاہیے، بہت احتیاط برتنی چاہیے تاکہ آپ دھوکہ نہ کھائیں، اس لیے کہ زیادہ تر امکان یہ ہے کہ وہ دھوکہ ہے، اس لیے کہ 25%، 20% ماہانہ، 12% ماہانہ، یہ سب غیر قانونی بزنسز میں ہو سکتی ہیں۔ قانونی بزنسز میں اس قسم کا فائدہ نہیں ہوتا، اس لیے کہ اگر اس قسم کا فائدہ ہوتا تو جو بڑے بڑے بزنس مین ہیں وہ اپنے بزنس چھوڑ کے جو 10، 12، 15% سے زیادہ ریٹرن نہیں دے رہے ہیں وہی بزنس کر لیتے ہیں۔ دوسرا سوال یہ پیدا ہوتا ہے کہ ہرمین کا حال فی الحال میں دھوکہ ہوا کہ ہرمین کے معاملے میں کیا ہوا؟ یہاں پر تو لوگوں نے باقاعدہ ایگریمنٹ آف سیل کیا تھا پراپرٹی کا، ہرمین نے لوگوں سے پیسے لے کے وعدہ بھی نہیں کیا تھا کہ 25% دیں گے، 30% دیں گے۔ تو ہرمین کے ساتھ یہ ہوا کہ دو چیزیں ہوئی، کچھ پراپرٹیز کے لیے انہوں نے 2-3 لوگوں کے ساتھ بغیر یہ بتائے ہوئے کہ پہلے سے انہوں نے کسی اور کے ساتھ ایگریمنٹ کیا ہے، بیسیکلی دھوکے کی نیت سے انہوں نے ایگریمنٹس کیے ہیں۔ تو سوال یہ ہے کہ کیا کیا جا سکتا تھا اور کیا کیا جانا چاہیے؟ تو اس کا جواب یہ ہے کہ کوشش یہ ہونی چاہیے کہ ہم کم سے کم پیسہ ایگریمنٹ آف سیل کے وقت پہ دیں، کوشش کریں کہ ایگریمنٹ آف سیل کو بھی رجسٹر کر دیں، پیپر میں نوٹس لیں تاکہ اگر کسی کو کوئی کلیم ہے اس پراپرٹی کے تعلق سے تو وہ آ سکے، اور کوشش یہ کریں کہ ایگریمنٹ آف سیل اور سیل ڈیڈ کے بیچ میں کم سے کم وقفہ ہو، جتنی جلدی ہو سکے سیل ڈیڈ کو لے کر، تاکہ ایک مرتبہ جب سیل ڈیڈ ہو جاتی ہے تو قانوناً سیل ڈیڈ کے لیے پریزمپشن یہ ہوتا ہے کہ قانون یہ مانتا ہے کہ یہ سیل ڈیڈ صحیح ہے، جو شخص اس کو چیلنج کر رہا ہے اس کو ثابت کرنا پڑتا ہے کہ یہ سیل ڈیڈ غلط ہے۔ لیکن ہم کو بھی پریکٹیکل رہنا چاہیے۔ حقیقت یہ ہے کہ بھروسہ ایک چیز ہوتی ہے، ایگریمنٹ آف سیل کے وقت لوگ بھروسے کی بنیاد پہ ایگریمنٹ آف سیل کرتے ہیں، لیکن کوشش کریں کہ ایگریمنٹ آف سیل کے وقت کے اوپر تحقیقات کیجیے ڈھنگ سے، اور کوشش کیجیے کہ سیل ڈیڈ جتنی جلدی ہو سکے اتنی جلدی آپ لوگ اپنی سیل ڈیڈ کر لیں۔ دوسرا معاملہ یہ ہوا کہ سیل ڈیڈ تو بنا دی انہوں نے، لیکن جن لوگوں نے ہرمین کے جن لوگوں نے سیل ڈیڈ کی ہے ان لوگوں نے اسی پراپرٹی کے اوپر بینک سے لون لیا تھا، اور وہ پراپرٹی بینک کے پاس گروی رکھی ہوئی تھی، اٹیچ ہونے والی ہے، وہ پراپرٹی بینک اٹیچ کر سکتا ہے۔ تو ہمارے ہی ایک جاننے والوں نے فلیٹ خریدا تھا 3 کروڑ روپے سے زیادہ میں، سیل ڈیڈ بھی بنا لی تھی انہوں نے، لیکن اب بینک والے ان کے پاس آئے کہ اس پراپرٹی کو گروی رکھ کر آپ کو جس نے بیچا ہے اس نے گروی رکھ کر ہم سے لون لیا ہے۔ تو سوال یہ ہے کہ کیا کرنا چاہیے؟ تو 2 چیزوں کی اشد ضرورت ہے۔ ایک تو یہ کہ لوگوں کو سب رجسٹرار کے آفس سے ای سی لینی چاہیے۔ ای سی کیا ہوتا ہے؟ انکمبلنس سرٹیفکیٹ۔ انکمبلنس سرٹیفکیٹ یہ ہوتا ہے کہ کسی بھی پراپرٹی کے تعلق سے اگر کوئی سی بھی چیز رجسٹر ہوئی ہے تو اس کی کاپیز آپ کے ہاتھ میں آ جاتی ہیں ای سی کے ذریعے، اور آپ کو معلوم ہوتا ہے کہ اس کے اندر کسی کے کوئی حقوق ہیں یا نہیں ہیں۔ دوسری بات جو بہت کم لوگوں کو معلوم ہے وہ یہ ہے کہ لون لیتے وقت بینکوں کے لیے ضروری نہیں ہے کہ رجسٹر کرائیں، ان کو حق ہے کہ خالی پراپرٹی کے اوریجنل ڈاکیومنٹس اپنے پاس رکھ کر لون دے سکتے ہیں۔ تو اس لیے دوسری چیز جو کرنی چاہیے وہ یہ کہ پیسہ کسی قیمت پر بھی اس وقت تک نہیں دینا چاہیے جب تک کہ وہ آپ کو اپنے اوریجنل سیل ڈیڈ پروڈیوس نہ کریں۔ اپنے اوریجنل سیل ڈیڈ نہیں دیں گے تو ان کو لون نہیں ملے گا۔ اگر ان کے پاس اوریجنل سیل ڈیڈ ہے تو زیادہ امکان یہ ہے کہ کوئی لون اس کے اوپر نہیں ہوگا۔ لیکن پھر بھی اس بات کو یاد رکھیے کہ آپ کو جتنی جلدی ہو سکے سیل ڈیڈ کو رجسٹر کروا لینا چاہیے۔ سوال یہ ہے کہ آخر یہ کیا کیا قوانین ہیں جو ریئل اسٹیٹ پہ لاگو ہوتے ہیں؟ اب بہت سارے قوانین ہیں۔ میری رائے ہمیشہ یہ رہے گی کہ آپ اپنی مرضی کے ایک اچھے ایڈوکیٹ کو کنسلٹ کر کے ہی پراپرٹی کو خریدیں، اپنے حساب سے بھروسے کی بنیاد کے اوپر آپ پراپرٹیز کو خریدنے کی کوشش نہ کریں، اس لیے کہ کافی قانونی پیچیدگیاں ہیں پراپرٹی کو خریدنے میں، لیکن جو آپ لوگوں کو احتیاطی تدابیر کرنی چاہیے کوشش کروں گا کہ وہ میں آپ کو بتاؤں۔ So what I was saying is that buying a real estate is pretty complicated because in India there are multiple laws which are applicable to the real estate. Some of the laws I have put up here, if you can see on the screen, they are the Transfer of Property Act, the Registration Act, the Indian Contract Act, the Land Revenue and the Land Reforms Act, and the Real Estate Regulation Act. दो किस्म की ओनरशिप्स होती हैं, एक फ्री होल्ड राइट होती है, यानी कि जो हम सब समझते हैं कि ये ओनर हैं, इसका मतलब ये होता है कि ये पूरी तरीके से उस प्रॉपर्टी के ओनर हैं और उनको पूरा हक है कि चाहे बेचें या उसके साथ जो भी करना चाहें करें, और ये जब बेचते हैं तो हमेशा हमेशा के लिए बिक जाती है प्रॉपर्टी। और दूसरा एक लीज होल्ड राइट्स होता है, जैसे अगर आप बार्टन सेंटर जो एमजी रोड की बिल्डिंग है, इसके ओनर्स ने डेवलपर को एक मुतय्यना मुद्दत के लिए दी है, तो जितने भी वहाँ पे फिलहाल कमर्शियल प्रॉपर्टी के ओनर्स हैं उनको उस मुद्दत जब भी ख़त्म होगी, शायद 25-30 साल बाकी हैं, 30 साल के बाद उनको वो प्रॉपर्टी वापस ओनर्स को दे देनी है, तो उसको लीज होल्ड राइट्स बोलते हैं। So that basically two kinds of ownership. One is a freehold rights, which is the most common right. The seller is the absolute owner. He has complete freedom to own and sell it forever. Then there are leasehold rights, which are where the actual owner has given away the rights to enjoy the right for a long period. And these lease rights can be sold for the period of the lease. Example is Barton Center on MG Road, where the owners who are owning the commercial spaces will have to surrender it at the end of the lease period. I think there's about 25 or 30 years remaining. रजिस्ट्रेशन को बहुत ज़रूरी चीज़ है, इसलिए कि हिंदुस्तान का नॉर्मल कानून ये है कि अगर आपको अपनी प्रॉपर्टी की ओनरशिप दिखानी है तो आपको रजिस्ट्रेशन के पेपर दिखाने हैं। आपके वालिद या वालिदा के नाम पे हो सकती है और आप उनके वरसा हो सकते हैं, लेकिन आपके वालिद या वालिदा के नाम से या आपके नाम से अगर जब तक प्रॉपर्टी के अंदर रजिस्ट्रेशन नहीं है तो आमतौर पे खरीदने वाला आपकी प्रॉपर्टी को नहीं खरीदेगा। आमतौर के ऊपर हर प्रॉपर्टी का रजिस्ट्रेशन मस्ट है, लेकिन हिंदुस्तान में कुछ चीज़ों के अंदर रजिस्ट्रेशन कंपलसरी नहीं है, जिसकी वजह से बहुत मसाइल होते हैं और बहुत सारे लोगों को धोखा हो जाता है। मसलन हिंदुओं के अंदर अगर हिंदू मजहब से ताल्लुक़ रखने वालों के पास अगर ओरल पार्टीशन होता है भाई बहनों में, उसके बाप के इंतकाल के बाद या माँ के इंतकाल के बाद, तो उसको रजिस्टर करना ज़रूरी नहीं है। और दूसरा फैमिली अरेंजमेंट अगर उनका होता है, फैमिली अरेंजमेंट के अंदर यह होता है कि न सिर्फ भाई बहन बल्कि जिसका इंतकाल हुआ है उसके दूसरे भाई, उनके बच्चे और बहनें और उनके बच्चे सब मिलके करते हैं, तो वो फैमिली अरेंजमेंट है। ओरल पार्टीशन आमतौर पर सिर्फ बच्चों के बीच में होता है। और आप सब जानते हैं कि मुसलमानों में ओरल गिफ्ट यानी हिबा की इजाज़त है और इसको भी रजिस्टर कराने की ज़रूरत नहीं है। हालांकि मैं समझता हूँ कि इसकी वजह से काफ़ी डिस्प्यूट्स हुए हैं, काफ़ी मसाइल हुए हैं और गालिबन हुकूमत को सोचना चाहिए कि इनका भी रजिस्ट्रेशन कंपलसरी हो जाए ताकि जो लोग प्रॉपर्टीज़ में इन्वेस्ट कर रहे हैं उनके पैसों के लिए कुछ गारंटी हो जाए। Normally the ownership of a property is proved by a person by virtue of registered deeds to prove his ownership. There are certain situations where there is no need for registration. For instance, a person dies and his legal heirs want to sell the property. So the connection would be the registered deed in favor of the father. So in India, the law is that any property worth more than rupees 100, if the ownership is changing, then it has to be only by a registered document. However, there are some documents which don't need registration, and I think it's not a good thing. Probably the government should seriously think of registering these arrangements also. The three examples are oral partition among the Hindus, the family arrangement that happens among the Hindus, and the oral gift or hiba among the Muslims. The oral partition among Hindus is normally between the wife and children of the deceased, while the family arrangement could also include the brothers and sisters of the deceased and their children. For some reason, the Indian law doesn't require these three documents to be compulsorily registered. Not a very good idea, but we really can't help it. That's the law right now. And therefore, my advice to everybody is please don't try and finish the deal yourself. Please consult an advocate of your choice who understands the situation. Now, first thing you have to check is whether the seller is competent to sell. And in India, basically, only two criteria are applied. One is whether the child is a minor, and the other is whether he is of unsound mind. And the third thing is whether he is the actual owner. So the three things that you need to confirm is, please confirm that the person who is selling the property to you is not a minor. Please also confirm that he is not of unsound mind, and please also confirm that he is the actual owner. Ownership प्रॉपर्टी का जो एस्टैब्लिश होता है, एहतियात का तकाजा ये है कि पिछले 30 साल के अंदर प्रॉपर्टी के ओनर्स एक के बाद दूसरे, दूसरे के बाद तीसरे जो बने हैं, उसकी चेन सही है या नहीं है, उसको ट्रेस करना है। तो वो बहुत अहम होता है। तो आप लोगों को इसके ऊपर ध्यान देना चाहिए। आपको अपने एडवोकेट की एहतियात अपनी जगह है, लेकिन आपको भी ये देखना चाहिए कि 30 साल से ए से बी और बी से सी और सी से डी और वो जो आपको बेच रहा है उसके डॉक्यूमेंट्स सही तरीके से ट्रांसफर हुए हैं या नहीं हुए हैं, वरना आपको काफी तकलीफ हो सकती है। अब हिंदुस्तान में और एक मसला है कि इंडिया के जो लैंड रिकॉर्ड्स हैं वो सर्वे नंबर्स और गांवों के हिसाब से मेंटेन्ड है। आपको शायद मालूम नहीं है कि आमतौर के ऊपर पूरे जो डेवलप्ड एरियाज हैं आपके शहर के, ये भी पहले किसी गांव का हिस्सा थे। फॉर इंस्टेंस क्वींस रोड के आसपास का एरिया ब्लैकपली कहलाता था। So basically the land records in India, they are maintained on the basis of survey numbers of villages, and many developed areas of the cities were previously part of a village. You have to understand that India was an agricultural economy, and therefore the legal presumption is कि सारी ज़मीनें काश्त की ज़मीन थी, they were all agricultural lands. ज़मींदारी सिस्टम की वजह से before 1973 ownership of lands जो है बहुत थोड़े लोगों के हाथ में था, और उसके बाद 1973 में जैसे आपको मालूम है लैंड रिफॉर्म्स एक्ट आए। इसके तहत जिन लोगों के पास हुकूमत ने एक लिमिट फिक्स की थी, उससे ज़्यादा ज़मीन जिसके पास भी थी वो हुकूमत ने ले ली उन लोगों से, और जिन लोगों के पास ज़मीनें नहीं थी उनको बांट दी। तो ये इसके अंदर हुकूमत ने शेड्यूल कास्ट और शेड्यूल ट्राइब जो कमज़ोर तबका है, इन लोगों के पास ज़मीनें नहीं थी, तो जिनके पास ज़्यादा ज़मीनें थी हुकूमत ने लेकर ये जो गरीब और कमज़ोर शेड्यूल कास्ट और शेड्यूल ट्राइब के लोग थे, उन्होंने ज़मीन हुकूमत ने उनको या तो फ्री ऑफ कॉस्ट या अपसेट प्राइस, यानी कई एकड़ ज़मीन 1 रुपये में, 1.5 रुपये में, 8 आने में दी है। So what happened was that India was an agricultural economy, and therefore all the lands are presumed to be agricultural. The situation was that before 1973, because of the zamindari system, people owned huge amounts of land. In fact, the entire lands were in the hands of a few people. And in 1973, the government brought about the Land Reforms Act. What happened was that they fixed a maximum number of acres of land which a person could own, and the rest of the land was taken away from those people and given to poor people. Lands were given to people belonging to the scheduled caste and the scheduled tribe at either free of cost or at an upset price. Probably in some cases 1 rupee per acre or 50 paisa per acre kind of money was charged, and lands were given to them. Now what happened was that these lands were again taken away by the rich people, and these people, since they got it free of cost, were very happy to take it, take whatever money they could get. So therefore the government brought in a law which simply said that all lands which are allotted to the scheduled caste and scheduled tribe people could not be sold without the permission of the government. Please remember that initially they said that it cannot be sold for 10 years or 15 years, but subsequently a law was made that even if it is written as 10 or 15 years, a land belonging to the scheduled caste or the scheduled tribe can never be sold without the permission of the government. So therefore the precaution that needs to be taken is, please ensure that the land you are buying does not belong to a scheduled caste or the scheduled tribe, and if it belongs to the scheduled caste or the scheduled tribe person, please ensure that he has taken the permission of the government to sell the land. Now, the next thing that people are almost always is that you apply for a government site. In Bangalore, it is BDA. In Delhi, it is DDA. And similarly, nearly every capital city of the country has a development authority which actually makes sites by acquiring properties from the farmers, paying them some compensation, and then allotting it to people who don't have sites. Therefore, the government puts the conditions that people should not sell off as soon as they get the property. And therefore, normally your BDA site will have a clause which says that it cannot be sold for 10 years from the date possession was given. So therefore, you need to ensure before you buy a property which is a BDA site or any site which is allotted by a development authority, you need to confirm whether there is any period which is prescribed for its non-alienation or forward to sell. Now, please understand that the safest site to be bought in Bangalore or in any other capital city where the government development authority forms a site is that the government acquires land from the farmers and the other people. It pays compensation to them. Then it forms the layout, and then it invites applications from people to apply for the land. Normally, the application has a condition that it would be allotted only to a person who files an affidavit that the applicant does not own any site or property. तो जब आप सबसे सेफ इन्वेस्टमेंट आपके पास बीडीए से या इसी तरह की जो डेवलपमेंट अथॉरिटीज हैं हर रियासत में, उनसे प्रॉपर्टी खरीदना जो है वो सबसे सेफ होता है। और आमतौर के ऊपर बैंगलोर डेवलपमेंट अथॉरिटी हो या दूसरी डेवलपमेंट अथॉरिटीज हो, ये लोगों की ज़मीनें ख़ासतौर पे किसानों की और फार्मर्स की एक्वायर करती हैं, उनको कॉम्पनसेशन देती हैं, फिर उसके अंदर लेआउट बनाती हैं और उसके बाद एप्लीकेशंस के लिए इश्तिहार देती हैं। और एप्लीकेशन जब लेती हैं तो उसके अंदर आपको नॉर्मली जिसने एप्लीकेशन दी है उसको एक एफिडेविट देना पड़ता है कि उसके पास कोई ज़मीन या कोई साइट नहीं है और इसलिए उसको ज़मीन दी जाए। उसके बाद बीडीए हो या कोई दूसरी अथॉरिटी हो, वो एक अलॉटमेंट लेटर इशू करती है। उसके बाद एक लीज कम सेल एग्रीमेंट इशू करती है। आमतौर पे लीज कम सेल एग्रीमेंट इसलिए कि वो 10 साल तक बेच न सके। उसके बाद पोजीशन सर्टिफिकेट दे देते हैं और सेल डीड आमतौर के ऊपर 2 शर्तों के बाद दी जाती है। एक, उसके जो भी नॉन एलियनेशन पीरियड है 10 साल या 15 साल जो भी है, उसके बाद और घर बनाने के बाद भी आमतौर के ऊपर सेल डीड देते हैं। तो आप अगर किसी की बीडीए की साइट खरीद रहे हैं तो आपको यकीनन इस बात के ऊपर तवज्जो देने चाहिए कि वो आपको ये सारे के सारे 5 डॉक्यूमेंट दे। यानी कि क्या दे? अपना एक एप्लीकेशन का लेटर दे, हुकूमत का अलॉटमेंट लेटर दे, पोजीशन सर्टिफिकेट दे और सेल डीड की कॉपी दे। This is the safest property that can be bought in Bangalore and in any capital cities or in other places where Karnataka Housing Board, the housing boards of various states or the Bangalore Development Authority, they follow 5 basic procedures. They call for an application for allotment. Normally, the application requires that an affidavit should be filed that the applicant does not own any site or property. Then they allot according to whatever prescribed procedure is there. After the allotment letter, they execute something called a lease cum sale agreement, which is basically to ensure that the person doesn't sell it for 10 years. Then they issue something called a possession certificate. And at last, if he has complied with the terms, which normally requires a house to be constructed, after the house is constructed and the 10 years period is over, a sale deed is done. So if you're buying a BDA site, you need to ensure that all these 5 steps were done and you have the documents to show all the 5. And then of course, if a person has bought it from him and he's selling to you, that person's sale deeds are also matching it. प्राइवेट डेवलपर से जो प्रॉपर्टी खरीदने का मामला है, बीडीए की साइट तो सबको नहीं मिलती है, तो प्राइवेट डेवलपर से आपको प्रॉपर्टी लेते हैं। प्राइवेट डेवलपर से जब आप प्रॉपर्टी लेते हैं तो उसके अंदर फिर वही है जो हमने आपको शुरू में बताया था कि ओनरशिप, जो ओनर بول رہا ہے کہ اس کے 30 سال کے ڈاکیومنٹ چیک کریں کم از کم کہ اس کی اونرشپ کا جو چین ہے وہ ٹھیک ہے یا نہیں ہے. پھر انکمبرنس سرٹیفکیٹ نکالیں کہ جو چین ہے وہ انکمبرنس میں دکھ رہی ہے یا نہیں دکھ رہی ہے. فیملی ٹری لیں تاکہ آپ کو معلوم ہو سکے, اس لیے کہ آپ کو معلوم ہے کہ ہندو لا کے اندر انڈیوائڈیڈ فیملی ہوتی ہے. تو اگر ہندو سیلر ہیں, ہندو مذہب سے تعلق رکھنے والے اگر کوئی سیلر ہیں تو کوشش کرنی چاہیے کہ اس کے بیوی بچے اور سب مل کر آپ کی سیل ڈیڈ پہ سائن کریں تاکہ کل کے روز آپ کو کوئی لیگل اور ستانے کے لیے کیسز نہ فائل ہوں. بہت ضروری ہے کہ جب آپ پرائیویٹ ڈیولپر سے لے آؤٹ کے اندر کوئی زمین لیتے ہیں تو آپ کو کوشش کرنی چاہیے اور اصرار کرنا چاہیے کہ اس نے اس زمین کو ریسیڈینشیل پرپز کے لیے کنورٹ کیا ہے یا نہیں کیا ہے. اور پھر یہ کہ اس نے میونسپل کارپوریشن سے یا جو بھی دوسری اتھارٹی ہے, بعض دفعہ ولیج پنچایت سے پرمیشن لینی پڑتی ہے, بعض دفعہ BMRDA سے لینی پڑتی ہے, الگ الگ جہاں پہ زمین ہے وہاں کی جو اتھارٹی ہے اس کے انہوں نے پلان کا اپروول لیا ہے یا نہیں لیا ہے. اور آخر میں یہ کہ اگر وہ 5,500 اسکوائر فٹ سے زیادہ کی جگہ ہے تو ریرا کا رجسٹریشن کمپلسری ہے. If you are buying a property from a private developer, please ensure that you are convinced that the chain of ownership of the owner for the past 30 years is correct. The encumbrance certificate shows all the transactions. Please take the family tree and ensure that all the persons shown in the family tree sign on the sale deed. Please ensure that the developer has taken conversion of the property from agricultural land to residential land. Please ensure that the municipal corporation or the statutory authority have approved the plan and it is constructed according to that. And now with the new law coming into force, which is called the RERA, any property which is more than any plots which are made on an area of more than 5,500 square feet, or if flats are made which are more than 8, that is, if there are 9 or more flats, then the property has to be compulsorily registered with RERA. RERA is a real estate regulatory authority. It has been formed for the sole purpose of protecting the interest of the buyers, and therefore it is much better that you always insist and buy a property which is registered with RERA. Now there are other things. ساری احتیاطیں آپ کر لیتے ہیں لیکن پھر بھی فراڈ ہو رہے ہیں. سب سے بڑا فراڈ یہ ہوتا ہے کہ امپرسونیشن, یعنی ایک آدمی آ کے کسی اور آدمی کی آئیڈینٹی لیتا ہے. خاص طور کے اوپر جو اینگلو انڈینس ہیں اور NRIs ہیں جو انڈیا کو چھوڑ کے باہر جا کے سیٹل ہو گئے ہیں, ان کی پراپرٹیز کو دیکھ بھال کرنے والا کوئی ہوتا نہیں ہے. اور مافیا کے لوگ ہیں جو ایسی پراپرٹیز پہ نظر رکھتے ہیں, اور جب کئی سالوں سے کوئی نہیں ہوا ہے, اس کا ٹیکس بھی نہیں بھرا گیا ہے, تو ویسی پراپرٹیز کا وہ لوگ ٹیکس بھر دیتے ہیں اور پھر فیک آدھار کارڈ بنا کے کوئی سی بھی ایک آدمی کو, عورت کو پکڑ کے لے جا کے جس آدمی کے نام سے پراپرٹی ہے اس کے نام سے اس کو جا کے سب رجسٹر کے آفس میں پراپرٹی رجسٹر کروا دیتے ہیں. یہ سب سے بڑا مسئلہ ہے, بہت خطرناک مسئلہ ہے. اور پھر دوسرا یہ ہوتا ہے کہ جو بیچنے والا ہے وہ آپ کو بتاتا نہیں ہے کہ اس پراپرٹی کے اوپر کئی کیسز پینڈنگ ہیں, اور خاص طور کے اوپر اپنے نیبرز کے ساتھ کوئی ڈسپیوٹ ہے تو وہ بھی نہیں بتاتا ہے, اور اپنے فیملی ممبرز کے ساتھ جو ڈسپیوٹ ہوتا ہے وہ بھی نہیں بتاتا ہے. تو ایسی صورت میں کیا کرنا چاہیے؟ ہماری ایڈوائز یہ ہوتی ہے کہ آپ کوئی سی بھی پراپرٹی لینے سے پہلے اپنے وہاں پہ آپ کے جو پراپرٹی کے ارد گرد لوگ ہیں, آپ کے نیبرز ہیں, ان سے جا کر پراپرٹی کے بارے میں, اونرس کے بارے میں تحقیق کر کے ہی پراپرٹی کو خریدیں, اور خریدنے سے پہلے پیپر نوٹس بھی لیں تاکہ آپ کو دھوکہ نہ ہو. Despite all these precautions, there are still several frauds that happen. Impersonation is a very big problem. In cases where properties are belonging to Anglo-Indians who have left the country, NRIs who have settled abroad, or people who have left the city long ago, the land mafia identifies such properties. They create documents, fake Aadhaar cards, bring a person, depending on whether it's a male or a female, give him that name or of the male or the female, and then register the property as if that fake person is the owner by going to the sub-registrar. And there is a huge danger that this could happen. There are so many people who have gone to jail doing this. There were mafias which were operating in Bangalore. Many of them have been identified and are behind bars. But they've got bail, they are out, and there are people who are always on the prowl. Then sellers, many times, they do not disclose that cases are pending pertaining to that property, especially if they have a dispute with the neighbors and the family members. Therefore, the precaution that you need to do is please don't go and buy off the first property you see. Please go and meet the neighbors, because anyway you have to go and stay there. Please ensure that you have taken all the precautions, and also please try and take a paper notice before you buy any property. Flats, huge developments are happening. The in thing is to buy flats. What the precautions I have stated above apply, and that is you trace the ownership of the developers and the original owners. You go and find the family tree of the present owner. And if you are already buying it from a person who is already owning a flat in a project, then you need to take another two extra precautions. One is that all flats have an association, and the maintenance is paid to the association. So please ensure that you obtain the latest maintenance paid receipt from the association. You also obtain NOC from the association that there are no arrears which are payable to you. Please ensure that the seller has paid up-to-date electricity bill before you register the sale deed. And as usual, advice is please buy the flats which are registered under RERA if the building has been constructed on or just before 2017 when RERA came into force. This in brief are the precautions that you need to take. Parting note, do all this due diligence yourself, but please take the advice of a good lawyer, and please don't attempt to do it on your own, because as I said, there are multiple laws that are applicable, and a lawyer may be the best person to advise you. Open to all the questions right now.
We have one question in the chat box. I'll just read it out. Recently got into an agreement with builder for JDA. I have provided the GPA for the same to the builder. Now that the flats are ready and we have taken a handover, what should I do with GPA? Is that still valid? How do I cancel it? What happens in case GPA still with builder and sale deeds are done to others and he is out of ownership?
Normally, you should be very careful when you are doing the joint development agreement. The GPA should specify that he can sell only the flats that have fallen to his share. Most of the times it is mentioned about the percentage of the ownership of the developer, and that he can sell the flats to the extent of the developer. And then there will be a sharing agreement which you would have done, which would clearly specify what flats he can sell. And therefore, there is nothing to worry as long as you have the GPA which specifies that he can sell only the flats which have fallen to his share. But if you have been careless and you have given him a GPA for the entire property, then you need to be cautious and you need to cancel that GPA. Please remember that the High Court and the Supreme Court have said that a registered GPA can be cancelled only by a registered cancellation of GPA document.
There is another question. When applying for BDA property, the buyer should not have a property on his or her name anywhere in India or only in Karnataka?
It's applicable throughout, because as I pointed out, normally these properties are built by acquiring properties from farmers. The government pays compensation which is very low, and therefore there was huge protest from the farmers, and therefore they brought in this law and said that all of you know the basic principle that individual rights give way to community rights or larger rights. So since it's for the larger benefit of the people, these layouts are made, and therefore most of the development authorities have this clause that you cannot sell the property for X number of years. It may be 8 years, 10 years, 15 years. It may vary, but almost all of them carry the condition that it cannot be sold because of the reason that I told you.
The next question is, what is the time frame to get the khata details after the registration of land?
Better to get it as fast as possible. No period is prescribed, but your documents are incomplete, and if you don't get it and you don't pay the taxes, the penalties are very high, and the interest that they charge and the penalty is too high. Therefore, please get the khata done quickly and start paying the taxes in time.
Someone has requested the slides pertaining to SC and ST to be displayed. I have shared the link of our WhatsApp group in the chat box. We have shared the slideshow in the WhatsApp group. You can access the entire PowerPoint PPT over there. Anyways, if Mr. Akmal, you are saying that if you can you please display the slide pertaining to the SC and ST.
Second, let me just check.
And then another question has also come. The developer are saying it's taking 2 months time to get khata. Is it right?
Yes, it sometimes it takes time. 2 months is reasonable.
There are no more questions in the chat box. If any participant wants to ask a question, they can raise your hand and I will unmute them and you can answer. Ms. Uzma Aziz, you can ask your question. Unmute and ask.
Assalamu alaikum.
Walaikum salam.
What are the precautions we need to take when we are buying a property from an agreement holder, not the actual property who's not the actual seller? He has an agreement with the seller and he is selling it to the third person.
Normally, you have to ensure that the agreement between the actual owner and him, he has complied with the terms. Otherwise, the actual owner can cancel that agreement. And the second thing you need to see is whether the agreement provides that it can be assigned, the right can be assigned, or if it has a nominee clause. These are the two precautions you need to take. If it has a nominee clause, you are absolutely right in getting into an agreement. You can enter into something called an assignment agreement, but you need to ensure that he has complied with the original agreement with the actual owner. Otherwise, the actual owner will cancel it, and your money and the money of the agreement holder both are at risk.
Mr. Farooq A. Siddiqui, you can unmute and ask.
Assalamu alaikum. I don't have any query. But all I want is if you can please redrop the WhatsApp group link and the PPT link. Somehow my network get disconnected in between, so I lost the connection.
No.
Okay, I'll just. Does anybody, if anybody else has a question, they can raise your hand.
There is a question in the chat box, I think.
Yeah. The question is, can you also share the details how we can verify if the registration is done correctly?
Income certificate will reflect that. If it is entered in the income certificate, most probably it will be a valid registration.
Ms. Uzma Aziz, you can mute and ask.
This agreement that the second person with the seller he has, under what conditions can the seller revoke the agreement?
If he has not complied, especially the time given by him, within the time if he has not paid the money, he has a right to rescind the agreement.
So he doesn't need to give him any kind of a notice or anything. He can just cancel the agreement.
Normally, notice will be insisted by the court if it is cancelling. The difficulty would be that as an agreement, as a person who is taking it from the agreement holder, you may not be knowing whether the notice has been issued or not. So normally, if the person has not issued the notice, it will be against the seller, because the court will simply ask him, if you are not happy that you are not paying the money, did you issue a notice? Why should we not think that you agreed to extend the time? That will be the question the court will pose, so that he has to show some communication or some notice that he has not complied, and despite repeated reminders, he has not done what he was supposed to do.
We've received another question. Properties which are registered in 1990, do we need to re-register again, as registration process did not have the latest photos and biometrics?
Not required.
The next question is, what is the time for DC conversion time? Because it has been pending for the past 9 years.
Normal thing that DC conversion should happen about 6 months. If it doesn't happen, the correct thing to do is to approach the High Court, so that they, because they normally don't respond to your notices as to why they are not converting the land. Two things should be done. One is, first try the RTI route. Ask them what happened to your file. If they respond, great. If they don't respond, please go to the High Court. High Court will pass a direction asking them to dispose of the application within a time frame, so that you will know where you stand, why the conversion was granted or not granted.
The next question is, a participant has said, Jazakallah khair for the presentation and information. I wanted to know if we wanted to consult Mr. Akmal, how can we make an appointment with you?
You can WhatsApp.
If a GPA does not have a timeline, or does a GPA have a timeline, or does it need to be renewed?
GPA is valid until it is either revoked by the person who has given the GPA, or the person who has given the GPA dies.
If anybody else wants to ask a question, they can raise their hand, and I will request you to unmute and ask your question. Yes, Mr. Uzma Aziz, please ask. Miss.
Is it compulsory in every BDA office or anywhere that we go to register that we have to pay them bribes? Uske bina kaam nahi hota hai?
Practically, yes, that's correct.
Any other question?
The other question, it says, is it safe to purchase a land or house from a GPA holder without the actual owner? Much better to, whenever you are buying it from a GPA, please take 2 precautions. The first precaution is, please ensure that the GPA is genuine. And number 2, please ensure that the person who gave the GPA is alive. Otherwise, you are taking a risk, because you have come across several cases where people have forged GPAs. In the sense that they have actually lost the original GPA, then they have forged the signature of the person, and if it goes to the court, you will be left with a forged GPA. So whenever you are buying a land from a GPA holder, please ensure that the actual owner is alive, and also please ensure that the GPA is genuine.
There is another question in the chat box. How can we know that the seller has already done an agreement with someone else?
Paper notice, checking of EC, and of course trust. That's why I insisted that if possible, please ensure that there is very little gap between the agreement of sale and the sale date, because otherwise there is no way of knowing that he has entered into an agreement or not entered into an agreement. Trust is very important, so therefore you need to know the person before you do the agreement.
Any other questions? You can raise your hand if you want to ask. And I have also shared the link to the WhatsApp group again. I have also put up our YouTube channels link in the chat box. You can follow us there also. The recording of this session will also be available on the YouTube channel, and the recordings of the previous sessions are also available. I don't see any other question, and I don't see any hand raised also. So if can we, if there are no other questions, we can conclude. There is a question which says that the person has started. I have started real estate recently. Any guidance for me?
Guidance to you is that if you are, according to RERA, if you are doing any deal for a project which comes under RERA and it is the first sale, then you need to go and register yourself as an agent with RERA. Very important. Because it is prohibited for a person who is not registered to act as a broker. Number two, please be very, very clear about your commissions from the beginning, because the sellers and the buyers subsequently dispute that they had ever agreed to pay you whatever you are claiming. The third thing is that please ensure that you take the precautions, because if you do one wrong deal, then you can forget the business, because word spreads very fast, and an agent can get a very bad name if he does a bad deal. So do a nice deal, do your own precautions, pay attention to what we have said here, and then only you proceed with it. Register yourself with RERA and be very, very clear on what you are expecting. If possible, take it in writing. Very difficult, people don't give it in writing, but at least have a mail communication, because now the court will accept the mail communication that your charges will be whatever, 1%, 2% of the sale consideration, or 15 days rent or whatever.
Another question has come कि मैंने अभी कुछ दिनों से रियल एस्टेट ब्रोकर के तौर पर काम शुरू किया है, मगर मुझे सही से लीड जनरेट करने नहीं आ रही है, इसके लिए क्या करें?
ये तो कोई रियल एस्टेट, अगर आप किसी रियल एस्टेट में काम किए हैं तो आपको मालूम होगा कि जिस तरीके से ये काम किया जाता है वो मेरा एक्सपीरियंस बता रहा हूँ। ऑफिस में अगर आप करें हैं तो आपको भी मालूम होगा कि आप निकलते हैं और देखते हैं कि कहाँ पर नए घर बन रहे हैं, ओनर से बोलते हैं कि भाई ये सेल के लिए है या रेंट के लिए है या नहीं है, और फिर उसके बाद अपने दोस्तों के ग्रुप में और फिर अपने जानने वालों में आप बोलते हैं कि भाई ये घर है, फलां इतना पैसा पूछ रहा है या इतना किराया पूछ रहा है। तो वो शुरू में आपके खुद के कॉन्टैक्ट से आते हैं, फिर रफ्ता रफ्ता बात फैलती है, फिर उसके बाद आपको ऑटोमेटिक आता है। आपके नंबर्स आपको छोड़ना चाहिए, छोटे छोटे बिलबोर्ड्स बनाकर उसको बांटें, तो कॉल आते हैं उनको ढंग से अटेंड करें और फिर उनको अपना क्लाइंट बनाने की कोशिश करें।
Do you have any other question? Anybody, if they have, please raise your hand. I don't see any hands raised or any question. I think we can conclude now. Jazakallah khair. So we host these legal sessions every second Saturday of every month. You can put in your suggestions about what you want the topic of the next session to be on the WhatsApp group, and please participate in the sessions. It is an interactive session. All your legal doubts will be cleared. And other than that, you can follow us on our YouTube channel. The link is there in the chat box. You can also join our WhatsApp group via the link in the chat box. Thank you.
Thanks.